Postal Service error followed an October 18th discovery that Election IQ had mistakenly sent duplicate mail-in ballots to wrong voters. Oh, upon information and belief, 1,800 mail-in ballots sent by the vendor have been lost. The provisional ballot shall not be counted. Like they said, you're not counting it, even if it is something that's come in on time. 20,000 missing votes in Pennsylvania. That's what the Democrats are hinting at. And this is a curious one because it comes out of Erie County in Pennsylvania, which is a very 50-50 county. It's not like a Democrat mega county where you'd expect the Democrats to want to go scrounge around for votes. It's a 50-50 split, and it's saying that the U.S. Postal Service and a third-party vendor who's supposed to be processing a lot of these ballots and managing these systems has done goofed bigly. And I don't care what party is not getting ballots. Ballots should be handled appropriately and not missing in the Postal Service, not being filled out and intercepted and returned by who knows who before they even get to the voters, as is happening in Colorado. And so what we're watching here is just episode after episode of failures and breakdowns of the system, which of course have been happening for a long time now. But here the Democrats are suing. They're suing the Erie County Board of Elections. And as I mentioned, Erie is right here in Pennsylvania, not too far away from Butler, which is right here. So Butler is where the Trump assassination took place. You can see in this county in 2020, it was 65-33 in favor of President Trump. Erie County, much closer, 49.8% to 48.8%. So it's like a 50-50 county basically. And the total number of votes, probably something like 140,000-ish. And if the margin, if we're talking about 10 to 20,000 votes that are now maybe missing out of that bucket, that's a pretty big number. So we'll go through that and see how the numbers align. So here is what the lawsuit looks like. It's a big problem in Pennsylvania if this is true. They tell us that this is an action seeking to enforce the election code to ensure that registered Pennsylvania voters may vote. The complaint seeks mandamus relief, enforcing Erie County Board of Elections to comply with the election code, which I'm sure they're already trying to do, right? But they're failing at this. Now, the Board of Elections has encountered numerous issues related to the mail-in voting process as a result of failures of one of its vendors. What if we didn't have mail-in voting? Well, there wouldn't be problems with vendors. There wouldn't be numerous issues. We wouldn't have label printing problems in Wisconsin, intercepted ballots in Colorado, and a multitude of problems in Georgia that they're not even responding to requests for information on. They won't allow hand counts. They tried, the DOJ, to put non-citizens on the rolls, right? It's happening everywhere we look. So just keep that in our minds when we talk about mail-in voting. We could eliminate a lot of these problems by just getting rid of it. So they reference this news article and they attach it, and I did pull that news article up because here's what it says. They say, look, there's news reporting on this from Erie Times in Pennsylvania. It says, your mail-in ballot still hasn't arrived. This came in 2 days ago, October 29th. We're like, and I don't care if you're a Democrat or a Republican. If our government says that they're going to mail you a ballot, they better do it because that's your vote. And if you're expecting it, they better do it. And I get so tired of the government. Well, we're just incompetent, so you just should excuse us. Well, you have claimed competence and you've rolled out all of these programs claiming that you can manage them appropriately without undermining the integrity of the election. Now we're showing you they don't work and you're still doing them. So now it's October 29th and a bunch of people aren't getting their ballots, allegedly, according to this news article from Go Erie. It says, the Go Erie Board of Elections and Voter Registration Office continues to work with the Pennsylvania Department of State and Josh Shapiro's office and the U.S. Postal Service and its third-party vendor called Election IQ, right? So we're not even running the elections. Third-party companies are. The same thing happened in Arizona with a company called Runback. Erie County clerk called Karen Chilcott on Monday provided potential remedies for people who are concerned they're not going to get their ballot in time. Mail-in ballots must be received by the office by the deadline, 8 p.m. Tuesday on election night. But what do you do if you haven't received your ballot? Well, you can email, request that the mail-in ballot be canceled and get a new ballot via express mail. Then the ballot would be sent directly to the voter registration office instead of Election IQ, which handles the printing. However, this request must be made by the end of the day 2 days ago, which is the deadline to request a mail-in ballot. So it's not good. You can see here's Karen Chilcott. She stands outside the office. They've been flooded with calls, and in some cases, the call volume overwhelms the phone system, and some callers are being disconnected. Employees are not hanging up on callers, they said. Yeah, right. Anyone who intends to vote early Tuesday should prepare to wait for several hours. Great job. Bring a snack, bring something to drink, and even a book. Going with another person is also advised, so you have someone to hold your place in line if you need to use the restroom. What? They're not standing in line like Disneyland. Some Erie mail-in ballots were also sent to the wrong post office. Last week, the county learned that 2 bins of mail-in ballots had been dropped off at a U.S. Postal Service processing facility in Pittsburgh, but were then sent to the wrong post office. However, Chilcott said on Monday she's concerned more ballots might have even been affected. The Postal Service error followed an October 18th discovery that Election IQ had mistakenly sent duplicate mail-in ballots to wrong voters. Oh, Chilcott has more meetings Tuesday with state officials. Great. So that's the report that they reference in the complaint. They also reference another one from WPXI. It says nearly 300 duplicate ballots incorrectly sent. They say upon information and belief here, the Democrats are saying to the election board, it appears that the post office has been unable to account for approximately 1,800 ballots just in one little incident. This is one minor microcosm of problems. 1,800 just in this one incident, in one location, Pennsylvania, one state, one thing we know about. Upon information and belief, they say, it appears that 10,000 to 20,000 voters who requested mail-in ballots have not received or submitted those ballots. Now, the Democrats might say, right, mail-in ballots have a higher propensity to be Democrat-ick, and ick is right. But they are not getting their ballots, right? So they are then, or even Republicans. I mean, it's a 50-50 county. So even if it's only in that one county, right, you presume maybe half those are Trump voters too. So, and either way, right, I want everybody to get their ballots. If the government makes a contractual promise, they're going to send the ballots out, not miss 1,800. Further, upon information and belief, over 300 voters received 2 mail-in ballots, one of which may not have correlated to the local races. So it's a free-for-all. And these vendor issues have caused registered voters substantial delays and hardships in casting ballots, potentially violating the right to vote of numerous electors. With 1 week away from the election, the Board of Elections has not yet properly even addressed these issues, and they threaten to disenfranchise thousands. Further, the board is apparently providing inaccurate information to voters about options that they can use to remedy these things, and so we seek injunctive relief to force them and to ensure that all effective voters may exercise their fundamental right to vote. Okay, so this is where you shoehorn in whatever you can, right? Injunctive relief precisely tailored to ensure that everybody can vote. So now they're saying, well, we've identified a bucket of 20,000 people, and so maybe after the election's over, they have now anchored this in, right? They're flagging this for future litigation. This is a problem. A bunch of people are disaffected. So when Trump wins Pennsylvania, they can come out. Trump wins by 10,000. They say, no, here's our bucket of 20,000 people who never got mail-in ballots. And so we should invalidate the election because it's greater than the margin of error. We're just anchoring these things in. They say, okay, the Pennsylvania Democratic Party is dedicated to, they say, improving, we'll say, wrecking the lives of their citizens. They're also coordinating the largest registration in Pennsylvania. They say, as of October 28th, they say 3.9 million registered voters are members of the Democratic Party. Gonna work on those numbers. In Erie County, Pennsylvania, 73,000 registered voters are members of the Democrats. The PDP is a major political party. We got significant resources that we've expended, and you've got jurisdiction over all of this. They say, upon information and belief, the printed mail-in ballots were available for distribution prior to October 9th to deliver to them. Then the Board of Elections contracted with a vendor, an outside company who is basically not accountable, at least here in Arizona, to distribute the mail-in ballots. Now, upon information and belief, due to the vendor's various failures, wow, as of October 28th, 315 incorrect ballots were sent to registered voters in Erie County. Oops. At least some of these incorrect ballots listed candidates for Pennsylvania state house races applicable to different districts. So they crossed the ballot lines. The board has claimed that letters were sent to the voters affected, but the board has not been made aware of any voter having received such correspondence, nor has the board shared the correspondence. Now, they have not publicly released the names of the affected voters to ensure that the affected voters cast the correct ballot. And additionally, the vendor's failures, coupled with ongoing delays with the postal service, have caused substantial delays in delivering the mail-in ballots as well. Says the PDP has been made aware by its registered party members of numerous instances where a voter requested a mail-in ballot weeks ago but has still not received it. The board has not publicly released the names. As of October 28th, just days ago, 40,000 mail-in applications have been approved by Erie County. However, only 21,000 have returned. This amounts to a return rate of 52%, which is 15 percentage points below the state average of 67%, which is among the lowest in the Commonwealth. Okay, but it's not the lowest in the Commonwealth. Further, upon information and belief, the Postal Service has no record of having received 1,800 mail-in ballots from its vendor. Stuff like that is just really problematic. Where'd they go? And is in the process of trying to locate these ballots. 1,800 people? What? At minimum, then, 1,800 voters' mail-in ballots have been lost and will not be delivered before the 2024 election. Insane. They say, upon information and belief, through Erie County Clerk Karen Chilcott, she's advised voters that they may email the Erie County Voter Registration Office to request their mail-in ballot be canceled, they can get a new one by FedEx. However, voters must submit this cancellation request like immediately, and that's already passed. And so assuming the voters did actually do this, their mail-in ballot would have been received yesterday, and further assuming that voters mail their ballots the same day, the timing is too late. It's one day after the deadline to mail the votes back. Given Erie's delays, such a remedy still threatens to disenfranchise voters whose mail-in ballots will not be received. And so we're saying we want you to force them to do something. They've declined our request to produce the names of the affected voters. So the Democrats want the names so they can go corroborate them and then turn out the vote for those people. Additionally, the Board of Elections has not set forth a clear mechanism to ensure that their votes are ultimately counted. And so they're going to cause people to be deprived the right to vote. Denying relief would inflict greater injury. And so we're asking for these things. Immediately release the names of all the affected voters. Immediately release all correspondence to the affected voters. Agree to a process whereby they, with representatives, observe the opening of duplicate ballots to see who received them, right? Like all these things they want to look at, and they should. I mean, it's a disaster. Multiple ballots going out to multiple people, 1,800 ballots now missing. Vendors' failures and delays, as many as 19,000 approved mail-in ballots have not even been delivered, right? In Erie County, requesting such ballots and other ballots were provided belatedly. So I didn't get mine. I have to go request it. Upon information and belief, the Board of Elections has not informed these voters of the delay, nor given them any guidance either way. In fact, the Board of Elections apparently is providing inaccurate information to the voters. Although the deadline for requesting the mail-in ballot was October 29th, all that's passed. Now, as of October 28th, only 21,000 ballots have returned. I don't buy that as like a real problem. Okay, maybe the average statewide is 67%, but that might just be the natural order of things. Additionally, upon information and belief, 1,800 mail-in ballots sent by the vendor have been lost. That's insane. Will not be delivered to the respective voters approved to receive them. Could you imagine if you lost $1,800? Hey, I need you to go deposit this at the bank, Rob. Oh, sure, boss. $1,800. Better not friggin' lose $1 of that, right? Going into the bank. Okay. These 1,800 voters will not receive mail-in ballots, and even if located, will not receive mail-in ballots in a timely manner. And this is just an allegation, okay? This is not fact, but this is their information and belief. I don't know where they're getting that from, but if it's true, that's a lot. Even if it's 100 mail-in ballots that are not getting delivered and they were promised to be delivered by these so-called vendors, and our government says that everyone's going to be enfranchised, right? Why are certain people not? Requiring thousands of voters to submit provisional ballots on election day will place a heavy burden on the polling locations, and provisional ballots can be disqualified in different ways, and it's not clear that they've even planned for a surge of provisional ballots, and so they continue to cause the delay, and some people may not be voting. And so given the delays, adequate remedies must be put in place. They should aggregate all mail-in ballots, put them all in the polling book, establish firm hours, be directed to keep the place open, and they want to, the Democrats are like, we're running the election now. All right, see what I meant when I said they'll come to terms on this? So then the elections board will come out and they'll say, I mean, theoretically, I'm not saying, I don't know the elections board's politics very well, or if this is a friendly lawsuit or how this will unfold, but it will. But my point is, it's a patty cake game. Then they come out, and then the board could theoretically come back out. And this happened a bunch during COVID in Michigan and in Pennsylvania, where they come out and they say, oh my gosh, you're right. It's not our fault that 1,800 people aren't going to get ballots. It's the Postal Service's fault. And so now we do, right? And they blame the feds. And then, well, yeah, let's do everything we can to fix this. And so then they come to a settlement agreement, and then they give the Democratic Party control of the election. And as you can see, that's basically what the Democrats are demanding here in this complaint. Some of those things you might say are good solutions. Others you might say those are overbroad, that give a power and benefit to the Democratic Party, but they're on it. And if our government really is losing 1,800 ballots here that we've identified in this one small microcosm, this is a giant election. 1,800 ballots is probably just the tip of the iceberg. The situation, though, means that they'll never admit it. So that is what is currently pending in Pennsylvania. Actually, these are Democrats who are suing to figure out where these ballots went. Our U.S. Postal Service trying to figure that out as well. Now, elsewhere, remember that in Virginia, they got sued by the Biden DOJ because they got rid of non-citizens from the voter rolls who declared themselves to be non-citizens. They did a very detailed check. This is what Glenn Youngkin said after the Supreme Court victory earlier this week.
The Supreme Court decision.
Well, Brett, it's a big win for common sense and for the Constitution. Of course, very pleased with the Supreme Court's ruling. And it affirms the fact that the process we're going through, in fact, isn't a purge. This is a process that we've been using for 18 years. When someone walks into a DMV, they identify themselves as a non-citizen. They have ended up on our voting rolls either by happenstance or by purpose. We go through a very clear process. You get a notice, you get 14 days to affirm you're a citizen. And if you don't, you come off the voter rolls. And of course, course, in Virginia, we have the ultimate fail-safe that you can same-day register and cast a provisional ballot. So everyone who is a U.S. citizen in Virginia can vote. And I encourage everybody, go vote. But this is a win for common sense and a win for the Constitution today.
Good call. We don't want non-citizens voting, and we want our elections managed appropriately. And we're going to the Supreme Court again to get their take on what's happening. In the Supreme Court of the United States, an emergency application for a stay coming up from Pennsylvania. They say the underlying courts have made a mistake, and they ask for a stay and a writ of certiorari granted, meaning the Supreme Court, they want them to hear this case. And so this is a battle over how the election will be conducted and how the votes will be counted. And you can see this one is going up to the Honorable Samuel Alito, excellent judge on the Supreme Court, as he oversees the Third Circuit coming out of Pennsylvania. They say, all right, weeks after mail voting began in Pennsylvania, Supreme Court judges, and less than 2 weeks before Election Day, a sharply divided 4-3 Pennsylvania Supreme Court, their highest court, left and departed from the plain terms of the election code law and dramatically changed the rules governing the mail-in voting. And the Supreme Court of Pennsylvania did so right in the middle of a general election in which millions of Pennsylvanians have already voted. Now let's talk about the law. The law says a provisional ballot shall not be counted if the mail ballot is timely received by county board of elections. A provisional ballot by a county board of elections. Well, that's interesting. Undeterred, the majority below held that election officials must count a provisional ballot cast by an individual whose mail ballot was timely received but could not be counted because it violated a mandatory rule, such as a lack of a signature, date, or secrecy envelope. This holding effectively creates a cure process for mail ballot errors, a process everyone agrees the General Assembly has deliberately chosen not to create. All right, so this should say not, right? If the elector's mail-in ballot is not, right? Shouldn't that say not right there? As Justice Mundy explained in the dissent, the majority's ruling usurps the General Assembly's plenary authority to direct the manner for appointing electors. As the three dissenters recognized on this question, the election code is clear. And so this court bears the responsibility of ensuring the state courts do not unconstitutionally intrude upon the role specifically reserved for the legislature. So it's saying that basically the county board, I guess, it's not about the timing, it's about the party. So by any standard, however deferential, that line has been crossed here. When the legislature says that certain ballots can never be counted, okay, at all, it says you cannot count them, even if they're timely received. A state court cannot blue pencil that clear command into always. Like it says, if it's timely, you're not counting it. And here, the General Assembly could not have been clearer. As the court explained in 2020 when it rejected the same arguments, our General Assembly, in clear and unmistakable language, dictated that in circumstances like this case, the provisional ballot shall not be counted. Like they said, you're not counting it, even if it is something that's come in on time. The Pennsylvania Supreme Court also made a mistake in changing rules governing mail voting in federal elections after mail voting commenced less than 2 weeks before Election Day. The Purcell principle, right, which is the one that we talked about that says you cannot interfere in a state election if you're a federal court when you're close to an election. Not to mention common sense says that when an election is close at hand, the rules of the road should be clear and settled. Whenever the temporal line, barring last-minute judicial rule changes, lies wherever it lies, this ruling below plainly crossed it. Nor is this a case where the court's intervention would somehow itself sow confusion or trigger remedial issues. No, in fact, to the contrary, a stay here would prevent the chaos because we've already said you cannot count those votes. This court should enter a stay. This is a case of paramount public importance, potentially affecting tens of thousands of votes in Pennsylvania that could lead to decisive control of the Senate or the presidential election. Whether that crucial election will be conducted under the rules set by the legislature or under the whims of the Pennsylvania Supreme Court is an important constitutional question. And if this Supreme Court fails to act, this is an egregious judicial usurpation of the legislature. Like the legislature, I don't know why they said that, but they did say it. Didn't even make sense to us. Wait a minute, if they get it by on time, okay, I guess it's the county board. They don't want to get those ballots. Got to go somewhere else. Applicants thus respectfully request the court enter a stay pending disposition of this case. Given that provisional ballots may be canvassed starting on Election Day, time is of the essence. Applicants request that this court expedite its decision on this application. In particular, we request the court, as of yesterday, set a deadline, and that was met. So now we're waiting for Alito and the court to decide. If the court determines a full stay is not warranted, then we ask that you order that provisional ballots cast by individuals whose ballots were timely received but invalid be segregated from all all other ballots, and if counted, be tallied separately and not included in the official total. So if you're not going to pause this, then make them separated. This court took the steps in 2020 to prevent mootness in another case in our state. And as that previous experience concerns, this is not going to prejudice anybody if you just make them separate this out. Now, in 2019, as part of an important bipartisan compromise, the General Assembly amended the election code to permit all Pennsylvanians to vote by mail without any excuse. Now, as part of the compromise, which was protected with an absolute non-severability clause, the bill also included certain rules that Pennsylvanians voting by mail must follow to have their ballots counted. And here, voters who cast mail ballots must seal them with a secrecy envelope, which protects privacy. Secrecy envelopes are then placed within mailing envelopes, bearing a declaration that voters must sign and date. All agree that these things, the envelope, the signature, and the date requirements are mandatory. If you fail to comply, your ballot is invalid and it is ineligible. Those are the rules. They set those rules back in 2019. The legislature and others, it was a compromise, right? See how this stuff happens? They negotiate, they come to a deal. Now, all agree too that the election code does permit Pennsylvanians to cast provisional ballots on election day. And so a provisional ballot, it's not your real ballot. You got mailed a ballot, you lost it. Well, you already have a ballot out there. So we have to make sure we're not counting that ballot and your new ballot. It's like you show up on election day. Hey, we already mailed you a ballot. We're not giving you another one. Well, okay, I need to vote. I don't have that. Okay, well, we'll give you a provisional. We'll only count the provisional if we need to. And in the event we can confirm your other ballot hasn't also already been received. So it's like a make-up plan B ballot kind of a thing. For example, an in-person voter who is unable to produce the required ID at the polling place or whose registration cannot be verified may cast a provisional ballot. Likewise, for a voter who requests a mail ballot who is not shown on the district register as having voted, which occurs when the voter never returned their mail ballot package to the board. Now, the election code, however, unambiguously directs a provisional ballot shall not be counted if the elector's absentee ballot or mail-in ballot is timely received by a county board of elections. There it is again. If it is timely received. You want to think that if it is not timely received. No, it is. You're not allowed to count them. Like it's unambiguous. Respondents and others reside in Butler County. They submitted mail-in ballots. They failed to enclose their ballots in secrecy envelopes. Instead, they just put their ballots right in the mail. So then, upon receipt, the board did not know that Gensler and Mattis had failed to use the secrecy envelopes because in accordance with the election code, it does not open the mailing envelopes until election day. But the board weighed the mailing envelopes and reached a tentative determination that they didn't use the envelopes. The board then logged the receipt of the ballots in the system called SURE and entered a code indicating the determination that no secrecy envelope was present. So here's the stuff where they just put them back in. SURE then sent Gensler and Mattis emails informing them that their ballots might not be counted because they missed the envelope. Now, if the board had subsequently opened the envelopes and found that they were present, it would have counted the ballots. But they didn't wait for the board's determination. Instead, they cast provisional ballots during in-person voting on election day. Now, the board, however, did not count those ballots because it's well settled that provisional ballots cast by individuals whose mail ballots had been timely received cannot be counted. That's the example. Even if the mail ballots were invalid. And so the Commonwealth held that in 2020. So then, after the board informed them that their provisional ballots were not counted, they sued. What do you mean? They argued the election code obligated them to count their provisional ballots. Then applicants intervened to defend the board's decision, and the Democratic Party moved to intervene. The trial court rejected their arguments, saying the election code unambiguously prohibits individuals who submit mail ballots that are timely received by election boards from having their provisionals counted. Commonwealth reversed, declined to follow the rule. Instead, it deemed the election code ambiguous. The court just came in, kind of changed it, and reversed. Then the Supreme Court in Pennsylvania affirmed that on different grounds. The majority said the election code prohibits counting a provisional ballot if the ballot is timely received by a county board. But it explained that a prior decision had referred to mail ballots without secrecy envelopes as void. It then relied on the definition of the word void, a term that never appears in any provision of the election code, to conclude that mail ballots without secrecy envelopes never existed as a matter of law. So the courts just said, well, we don't really care about envelopes. Thus, the majority said that the mail ballots without secrecy envelopes were never received in the first place. And so you can see this mental gymnastics that this judge went through. That issue is true of all other ballots that violate the mandatory rules, like those without valid signatures or dates, all because these ballots are never, quote, received, and anyone can cure this. So other judges dissented in that opinion. Because their mail ballots were indisputably received by the board by the deadline, the election code prohibits their provisional ballots from counting. It's a policy choice, and so you don't get to reverse it. And the justices criticized criticized the original decision there. Now, although Butler County Board of Elections is the only county board that is a party to the ruling, other 66 county boards are expected to adhere to the Pennsylvania rules, and they issued guidance to mandate they do so. And so we're now here. Election day is right around the corner, and apparently, if the Pennsylvania Supreme Court ruling remains in place, county boards will be forced to ignore the election code, which says do not accept them, and count provisional ballots cast on election day by those who submitted defective mail-in ballots. So I guess there's going to be questions about whether they're double counted. Now, county boards may start counting provisional ballots on election day as it stands right now. And so you should grant this, Your Honors. This court will grant a stay if it's likely that 4 of you will agree with us and will win in a victory. A stay is warranted because they're violating the Purcell principle alone. Here, the Pennsylvania Supreme Court dramatically upended the rules. They established a cure process for all mail-in ballot errors after mail-in started and less than 2 weeks before the election occurred. So all of this should be stayed. The majority decision should restore the status quo. A stay is warranted also because you're going to grant cert and you're going to find in our favor. Under any standard, their interpretation of the election code is not even remotely plausible. In fact, they've interpreted it to be the opposite of what it actually says. This question is tremendously important. In recent Pennsylvania elections, tens of thousands of ballots have been rejected for violating the rules, and now they'll all count. And voters got no mulligan in those elections. In 2020, under the General Assembly's plain directive, about 1% of returned mail ballots were not counted because of secrecy envelopes. That's a big number. Rejection rates for missing signatures and dates have varied, but each type of error could disqualify over 10,000 ballots. Now, thanks to the Supreme Court's decision, those individuals get a redo. They get a provisional ballot. They can just show up there and vote again. Because Pennsylvanians voting by mail already get notice of mail-in ballot errors, tens of thousands of provisional ballots that are flatly illegal under the code are likely to be counted. That outcome risks tainting or even flipping the result of the election in Pennsylvania, including the state, including the Senate race, and others. This is unacceptable, Supreme Court. Now, furthermore, failing to correct this would send a strong message that the Electors Clause is toothless and state courts can do whatever they want. Equitable considerations also favor a stay. Public interest favors a stay because we want fair elections. And finally, at a minimum, the court should order that provisional ballots cast by individuals whose mail ballots were timely received but defective be segregated from all other ballots and not included in the official vote tally. Court already took that step to prevent a similar case from becoming moot, and so all of this is going up to the United States Supreme Court. You can see a lot more details here in this brief, and it's being sent in there by John M. Gore out of Washington, D.C., the Gallagher firm out of Pittsburgh, Pennsylvania, and more. We'll be here continuing to cover this, my friends. Thanks for subscribing, sharing our channel, and joining us as we do. We'll see you back here on the next one.